Hey everyone, welcome back to the channel. Today's lineup is absolute chaos from start to finish. We've got a brand new sovereign citizen meltdown that completely spirals out of control, plus an update on a familiar, crayon-chewing repeat offender you already know all too well. But before we even get into either of those disasters, we have to start with something even more unhinged. A full-blown male Karen, who looks like he grew up snacking on lead paint, decided it was a smart idea to threaten a judge right outside her own courtroom. And no, that's not an exaggeration. This man actually said out loud that he wanted to hang her, like that's a normal thing to say in public. So buckle up, because if you think that's insane, trust me, this episode only gets wilder from here.
That ends in 8883. Can you please unmute your device and tell us your first and last name? It's *6 to unmute. Hit star and 6 to unmute the device. 8883. Please hit *6 to unmute your device. We can't call your case if we don't know who you are.
Hello?
Yes, please tell me your first and last name.
Well, my name is Benjamin Meyer, M-E-Y-E-R, unlike the paperwork that I've been sent. That it says M-Y-E-R. It is not me. I am here under duress.
Mr. Meyer?
Yes, ma'am. M-E-Y-E-R, not
Please
the person you had
talking,
spelled on this paper.
Mr. Meyer, please stop talking.
Yes.
The court will call the case of the State of Michigan versus Benjamin Meyer, case number DIB 053809. Is that correct?
What's for the people?
267659. Thank you. Mr. Meyer, you've placed your name on the record a number of times at this point. You're here for a contempt hearing today. Mr. Meyer, you owe this court $168. When do you plan to pay it?
I do not plan to pay it because I don't owe it. Period. End of discussion.
Okay. Well, then what I'm going to do, Mr. Meyer, is find you in contempt of court.
And what you're going to do is find yourself in a 1984 federal lawsuit.
All right. Let's do it however you want to do it. You're found in contempt. You need to be here in person.
Absolutely not. I will not be
12th.
coming to your court.
Excuse me, sir, do you kiss your brother with that mouth? And honestly, I probably shouldn't have even stepped in, because I should have just let him keep talking. He is nowhere near done destroying his own life. Every single sentence that comes out of his mouth is like another shovel of dirt as he buries himself deeper and deeper. And the craziest part is we're watching it happen in real time. He's not defending himself. He's not helping his case. He's actively handing the court more reasons to bury him. This is one of those moments where you sit back and think, you really woke up today and chose self-destruction, because this meltdown is pure madness.
You?
And what you're going to do is find a gunfight and a fight on the side of the fucking road.
All right.
This fine and fee was paid 10 years ago or more. Now, you can either fucking listen or we can do this out in front of your court.
Mr.
This
Meyer?
fine was paid 10 years ago. Will not be paid again. You fucking damn near shot me and killed me. Are you fucking kidding me? Have you goddamn lost your fucking minds?
30 days in the Washtenaw County Jail. Keep it up. We'll go with more.
And we'll see you hung in front of Washtenaw County Jail.
All right. Your threats, I'm going to report that to the Attorney General.
I'm reporting you to the fucking Attorney General. Are you fucking nuts?
Okay. Everything you're saying is being recorded.
You are a goddamn tyrant.
All right.
I called the goddamn fucking attorney's office and you fuckers rejected me. Are you insane?
3 days in the Washtenaw County Jail. Keep it up.
Oh, you'll find yourself in prison, bitch.
All right.
You think you're a goddamn king? You're a fucking tyrant.
90 days in the Washtenaw County Jail.
Below me, bitch.
Listen, if she really plans on taking care of you, she'd better pull up directions to the county jail, because that's exactly where you're headed. And you'll be spending the next few years surviving on all those fake compliments you keep throwing around. And let's address this other little fairy tale too. If you really paid your fines and fees like you claim, proving it is easy. Receipts. That's it. No speeches, no victim routine, no word salad, just receipts. This isn't rocket science. Now that we've cleared out that nonsense, let's head.
No. Mr. Smith, it's the middle of page 1. Yes. He does not want to deal with me because he does not have a contract with 4D, with any 4D workers, so he doesn't want really to talk to me. He wouldn't talk about the motion, so I'm going to submit a recommendation that the motion be denied.
Okay.
Okay, he's very difficult. I know that you read through all the paperwork. He is the individual that was talking about how he has continued to talk about that he's, he has all these constitutional rights, and he's I don't know. I can't even explain what it is he's trying to get to or what he's trying to talk about. So
okay.
So there's not much I can do. He just basically told me that I'm not someone that he's willing to talk to because he doesn't have a contract with me.
He maybe doesn't want to talk with me either, but you can get Sarah. You can bring him in. And
I can get him.
That.
Yeah, and I'm in the process of sending you the recommendation that the motion is denied, but I can go and get him, bring him in.
Thank you.
Thanks.
The motion of the defendant, Father David Smith Jr., to modify custody and parenting time. This hearing is being conducted via Zoom. Present is Sherry Zorn, as well as David Smith Jr. Mr. Smith, it is now 9 o'clock, and you are before Judge Brolick. Good morning.
Sir, I can barely hear you. I was in my vehicle where I could, and fortunately, we're back in front of Title 40 identifications. If you can give me a second so I can make it back out to my vehicle so I can hear you, I would appreciate it.
Okay. Do you want to zoom back in then?
I'm parked right outside the door. If you give me 60 seconds. I had to come back inside because whatever just went on.
Hey, Mr. Smith, your current parenting time is alternating weekends, Friday at 5 till Sunday at 7 with your 2 children. Is that correct?
Yeah, but we work outside of the order. I mean, I got numerous evidence that we do work outside of the order. That was arbitrarily done to maximize the dollar amount pursuant to Title 4D.
Well, that's wonderful that you can both be flexible about parenting time with your work schedules and the children. That's once we work together. I'm just noting that the last order of the court, August 2015, I do review these files in advance. I review your motions. I review the past orders. I review the history of the case, Mr. Smith.
I appreciate that.
So I'm just noting that the last order gave you specific parenting time, alternate weekends, Fridays at 5 to 7 Sunday at 7, and you could have additional parenting time, but that's what your absolute minimum. Now, in your motion, you're asking for an 80-20 split pursuant to your 14th Amendment to the U.S. Constitution. I don't know, this is not a constitutional issue. It's a state law issue, Mr. Smith. And in order for, first of all, have you talked with Ms. Zorn this morning? Do the two of you have an agreement? Certainly, if you have an agreement, you know what's best for your 2 children.
Sir.
We do not.
Okay. So, is there any merit in talking, Ms. Zorn and Mr. Smith?
I object. I made my kids.
4. Did he seriously just say, I made my kids in private, so I'll raise them in private? What does that even mean? And honestly, I would hope the making part happened in private and not out in public. But that has absolutely nothing to do with what's happening right now. You didn't privately bring this issue to the court. You dragged it straight into a public courtroom. And unless you somehow managed to reproduce entirely by yourself, which, spoiler alert, you didn't, this argument doesn't carry a single ounce of legal weight. It's just another sovereign citizen catchphrase that sounds deep in their head, but the second you hear it out loud, it completely falls apart.
This is a non-TANF case. Am I presumed to be innocent at this time with all my constitutional rights in full force and effect, sir?
Absolutely, you're innocent, but there's no criminal charges here, so I'm not sure what you're innocent of.
But,
Mr. Smith, no one's accusing you of anything. I'm just asking, normally the two parents will talk, and maybe they come to their own agreement, but that apparently is not to be possible this morning.
This is a non-TANF case getting treated as a TANF matter. I want split custody, mutual agreement, all Title 4D incentivization ceased and desist immediately. I will be sending letters out today to all parties that touch this case negatively, and I'm pursuing charges 42 U.S.C. 1983 and Article 3 corporate deprivation of rights. This is arbitrarily done underneath color law. I do not consent. I have not contracted with Title 4D. I would submit into the court's Blessing versus Freestone, Wehunt versus Ledbetter, sir. I don't presume ignorance on the court behalf today, therefore I'm left to believe something much more sinister is going on here.
Right, Mr. Smith, it's not a constitution, under state law, Michigan law, there must be...
I do not acquiesce to state law, sir. I operate on federal law only. This is impeding my rights. I am going to transfer to Article 3 court and pursue. I'm going to file an emergency injunction if I can't even make my bills. Due process has been violated. Fair Creditors Act of 1970, you guys are taking well over half of my check. I can't even make my bill. This forces me into my 13th Amendment, which is enslavement. Pursuant to no lawful money, this is a bill of pen and penalty underneath Article 1, Section 16 of the Constitution, sir. I do not consent. I do not consent. I have not.
Let me just go out on a limb and assume you did consent to making that baby, because it's pretty hard to pretend you didn't when another person was clearly involved. So yes, your sudden, convenient lack of consent has officially been noted for the record. But let's be honest, it changes absolutely nothing. Nobody in this courtroom is clutching pearls over it. And nobody is losing sleep because you decided to throw out a sovereign citizen catchphrase at the last second. It's just another empty line that sounds clever in your head until you say it out loud, and it collapses under basic logic.
Position is duly noted for the record, Mr. Smith. Mr. Smith, under Michigan law, which this court is bound to follow, there must be a change of circumstances that would support a modification of custody and parenting time. In your motion, you've not alleged any change of circumstances that would warrant a review of custody and parenting time. So with all due respect, the court at this time will deny your motion to change custody and or parenting time.
I have the right to my privacy. I can't even make my bills with what you guys have done here today. I can't, honestly, I have proof. I would like to submit into the court's Exhibit A if there is no objection. I have a pay stub right here. I work 58 hours a week at $30 an hour. I come home with less than $300. I can't even make my bills.
That's an issue of child support, Mr. Smith. You're asking to modify custody and parenting time today.
I am not here. I'm here to
support. File such a motion.
4D. Sir, do you have a contract in dispute with me? I'm asking the court, Ms. Zorn, to place into the court all evidence she has partied on my contract. If not, I motion to dismiss with prejudice, failure to state a cause of action. This goes against my Constitution, sir. I understand Michigan law, but it must be in compliance with the Constitution. This has violated me as a man numerous times, and now I can't even make my bill. I'm asking you to give me 50-50 split of my kids. I made them in private. I will raise them in private. There is no need in dispute, nor has there ever been. You know what, sir? Underneath Article 1, Section 13, Paragraph 5, I want to face my accuser. If we could please swear Ms. Zorn in so I could face my accuser here today, sir, I would appreciate.
Honestly, I think we'd all be better off if you went back to whatever imaginary constitutional law school you think you graduated from and took a refresher course. Because this whole, I have the right to face my accuser routine, that's a criminal case argument, not a civil matter like child support. You're out here quoting the Constitution like it's some kind of magic spell that makes consequences disappear. But none of what you're saying applies here. And the wildest part is everyone in that courtroom knows it, except you.
All right, to Mr. Smith, perhaps you should consult a constitutional lawyer. This matter is
no, sir.
guided by state law. The court has made a decision.
Sir,
There's no
it sounds
change of
like you already
circumstances that
have
would
a
warrant a change of
predetermination of
custody
this
any time. The court will not argue
Sounds
over
like you
you,
already have
Mr. Smith.
predetermined.
So that will
Sir,
conclude,
do
so
you
you
have
can zoom out.
predetermination of this case?
An order will be entered. All right, Mr.
Do
Smith,
you have a
consult an attorney.
predetermined?
Quick shout out to Enemy of the State TV for sharing this footage with me. If you want to watch the full uncut video, the link is waiting for you down in the description. Now let's move into our final case of the day. And this one isn't so much a follow-up as it is the next chapter in a saga we've already covered. The sovereign citizen you're about to see was previously found responsible for a driving infraction. But since he didn't like the outcome of that informal hearing, he decided to post bond and demand a formal hearing instead. And trust me, the way he plays this round is just as reckless, chaotic, and self-destructive as the first time.
Traffic stops and what to look for.
Okay, were you on duty on May 24th, 2024 at approximately 9 p.m.?
I was.
What was the weather like at that time?
Weather that day was clear, and it was still light outside.
The road conditions?
Dry.
Okay. And you were on patrol at that time?
I was.
You were in a marked patrol car?
I was.
Where were you on patrol?
I was patrolling the downtown area near 11 Mile in Washington.
That's in the city of Royal Oak?
It is.
What happened at that time at those crossroads?
I was stopped at the 11 Mile and Washington light facing westbound. I had a green arrow and a vehicle proceeded eastbound on 11 Mile through a light, which gained my attention. That light was red for them, which drew my attention to that vehicle.
Okay, what type of vehicle was that?
I believe it was a black 2024 Ford Edge.
Is your vehicle equipped with a dash cam?
It is.
Judge, at this time, I'd like to play that video from Officer Moran's dash cam.
Okay.
Can the court see that?
I can.
Officer Moran, you can see that video that I
can.
up?
Yep.
Okay. Just playing that video now, Judge.
Okay.
Edward Charlie 6501 6501.
Yes.
Judge, I'm just gonna stop that video here.
Okay.
If defense would like to play the rest of the video subsequently, we can. I just wanted the court and Officer Moran to see the stop.
All right.
Is that the video taken from your patrol car?
That is the vehicle for my patrol vehicle.
Does that fairly and accurately portray the events of the incident that led to the defendant being issued a civil infraction on that date and time?
It does.
Your Honor, I'd ask that that video be admitted into evidence.
All right, so admitted.
Officer, so what do you see on that video?
What I see, like I spoke to earlier, I was stopped at the 11 Mile at Washington light facing westbound. I got the green arrow to turn southbound on Washington when a vehicle proceeded eastbound through, obviously, the red light.
And then you pulled that vehicle over?
Yes, I immediately initiated a traffic stop.
And that was on 11 Mile in the city of Royal Oak?
It was, yep.
When you approached that vehicle, did you observe the driver of that vehicle?
I did.
Do you recognize the driver of that vehicle on this Zoom today?
I do.
What's your objection?
Because I was traveling.
Right. My mistake? You weren't driving, you were traveling. Because in sovereign citizen land, swapping one word is basically the same thing as rewriting the law. And apparently, if your gear shifter is in T instead of D, your car magically transforms into a road canoe and traffic laws just stop applying to you. It's the same tired fantasy every time. Play word games, twist definitions, and pretend you've unlocked some secret legal cheat code. But here in the real world, flipping a letter on the shifter doesn't exempt you from the motor vehicle code. It just makes you sound ridiculous, while the consequences keep rolling in.
Go ahead. You can answer the question, Officer Moran.
Yes, I do see the defendant in the court today.
Your Honor, let the record reflect that Officer Moran has identified the defendant, Anthony Mathis.
The record will so reflect.
When you pulled the defendant over, did you have a conversation with him?
I did.
And in that conversation, did he admit to you that he had driven through the red light?
He did.
And ultimately you issued him a ticket?
I did.
What was that ticket for that you had issued him?
I actually issued him an impeding traffic ticket.
Okay. But that's not what he actually did, correct?
No, that's not.
Why did you issue him an impeding traffic ticket?
Mr. Mathis at the time had a good driving record. He knew what he did. He told me he admitted to it, and he had a good attitude on the road, so I chose to go an impeding traffic ticket.
I object.
What's your objection?
I never admitted to anything. Do you guys have that on the record? Did you guys pull that up that I admitted to something?
You'll have a chance to.
That's false.
Mr. Mathis, you'll have a chance. Your objection's overruled. This is his testimony from his memory. You'll have a chance to testify yourself and add any additional evidence here. So at this point, that is not a proper objection. It's overruled. Anything else to add there to that?
What, just very briefly, Judge, what infraction did you actually observe?
I could have wrote him two infractions, either disobey traffic control device or disobey traffic signal.
And that's what he actually did, correct?
Correct.
Judge, I have nothing further at this time.
Now, Mr. Mathis, it's your opportunity to ask Officer Moran any questions that you feel are necessary. Now, I just want to instruct you. You'll have a chance to testify if you choose to in a moment. Right now, it's anything that you say should be in the form of a question directed at the officer. If you're going to start testifying, I'm going to have to interrupt you and redirect you. You'll have that chance in a moment. It's just to ask questions. So go ahead with any questions you have.
All right. Well, for the record, is there any injured party? Do we have a sworn affidavit or complaint from an injured party?
No, there's no injured party.
Okay, so we don't have any injured party. So Judge, you've been sworn in to uphold the Constitution, correct?
I'm not on the stand. I'm not answering any questions like that, Mr. Mathis, excuse me.
So what type of court is this? Is this Admiralty Maritime Law?
Mr. Mathis, right now is your opportunity to ask Officer Moran any questions that you want to. If you're going to make some legal objections or something along those lines, you can do that in your closing. But right now, this moment in time is for you to ask Officer Moran any questions.
Okay. Well, for the record, we don't have any injured parties. Correct?
Judge, that's been asked and answered.
Sustained. He already answered that question.
Right, correct. I just wanted to make sure that we got that on the record. So if there's no injured party...
Because you broke the law. Plain and simple. You blew straight through that red light. The officer watched it happen with his own eyes, and the dash cam captured the entire thing crystal clear. There's no mystery here, no conspiracy, no secret loophole to wiggle through. It's just you getting caught on video doing the exact thing you're now trying to deny. And at this point, the games are over. It's time to take responsibility, because that's the reason we're all sitting in this courtroom today.
think that's an appropriate question for
It
Officer
shouldn't,
Moran.
it should have been no type of
agree.
charge of
Hang on,
anything.
Mr. Mathis. When there's just like when you made an objection, we all waited for the court to make a ruling. That's what you need to do. So Mr. Klusny just made an objection that your question was actually more of a legal argument. I think that's what your objection was, Mr. Klusny, correct?
Yes, Judge, I don't believe there was a question directed to the officer.
So I'm sustaining that objection. And again, you can make those legal arguments or whatever the case is that you want to make at the end. Right now, it's just questions or not to Officer Moran. Anything else?
No, that's the only question that I have. If there's no injured party, he said no one was injured.
All right. So, Mr. Klusny, would you like to call any additional witnesses? I should ask you first, any redirect of Officer Moran?
Not at this time, Judge.
All right. Then any additional witnesses, Mr. Klusny?
No, Your Honor.
Mr. Mathis, will you be testifying, or do you have any witnesses that you'd like to call on your behalf?
Okay, so let me make sure I'm understanding this correctly. You have no witnesses, no evidence, and you're not even attempting to challenge the officer's sworn testimony. So what exactly is the plan here? What's the defense? Are you just hoping the judge randomly blanks out and forgets everything he literally just heard? Because that's honestly what it sounds like. None of this strategy makes sense. None of it adds up. It's like watching someone try to win a case using pure vibes and delusion. Somebody explain this in the comments, because I'm genuinely struggling to understand what he thinks is happening right now.
Mr. Klusny, then your closing statement?
Judge, based on the testimony of Officer Moran and the video, it's clear by a preponderance of evidence that the defendant committed the offense of disobeying a traffic signal. The authority for the stop comes from MCL 257.611 or 257.612. I believe that's for the traffic control device. The video in this case could not be more clear, Judge. You see Officer Moran is in the left turn lane. He gets a green arrow, and the defendant in his vehicle has a red light, drives right through the red light. If Officer Moran didn't stop, he would have hit the defendant's vehicle because he went right through the red light. It's rare that we have a video that is as clear as this, Judge. And the officer tried to give him a break by writing him for an impeding instead of what he actually did, which was disobeying a traffic signal. And I believe it's clear, based on the testimony in the video, that the defendant is responsible for that traffic offense of disobeying a traffic signal.
Repeat your change.
Yeah. Thank you.
You got the light.
Mr. Mathis, your closing argument?
Well, what I would like to say on the record is no one was injured. There's no injured parties. If you guys can't bring forth any injured party, then why are we still here? I need this to be dismissed, and the funds that was issued on the bond account needs to be reimbursed to me. Period. You guys don't have any injured party here. Based on the Constitution, the Sixth Amendment, if you guys can't bring forth the accuser, then this needs to be dismissed.
The officer is literally sitting right there with you on the Zoom call, and he just finished testifying directly in front of your face. But like every other sovereign citizen legal scholar, you're completely misunderstanding what rights you actually have and when they apply. You're trying to use a criminal trial argument in a civil hearing while representing yourself. And it just doesn't work like that. This isn't some hidden constitutional cheat code you unlocked. This is you publicly proving you don't understand the basic difference between criminal court and civil court. And the more you push it, the worse you make it for yourself.
Anything else, Mr. Mathis?
Not at the moment.
All right. Was there a bond posted? I'm not quite sure what he's talking
Absolutely.
about.
Judge, it looks like there was a $175 bond posted. Judge, I apologize. The file is here. I'm going to send the file into court.
Mr. Klusny, the amendment was to disobey a traffic signal, which is okay.
I apologize, Judge. The file coming into you.
That's all right. The amendment that the people made here was to disobey a traffic signal. Is that correct?
That's correct, Your Honor.
All right. The court's heard the testimony, the arguments of the parties, reviewed the video that was introduced as evidence. The video shows clearly the vehicle driven by Mr. Mathis go through a red light, the traffic signal at 11 in Washington. The standard here at issue is preponderance. The video showed beyond any doubt, really, that that's what occurred. Also, there's testimony from Officer Moran that that Mr. Mathis did actually admit on the roadside that he had done what was alleged to have occurred here today. That testimony was uncontroverted by any other evidence that was introduced. With that, the court does find Mr. Mathis to be responsible for the amended charge of disobey a traffic signal. That's a $150 fine. Mr. Mathis has posted a $175 bond, so the court will apply the bond to the fine of $150. There's a $25 refund coming to Mr. Mathis.
All right, guys, that's going to do it for today's chaos. 3 sovereign citizen disasters, and all 3 did what they do best: lose in spectacular fashion. Nothing but courtroom nonsense, cell phone after cell phone, and a whole lot of delusional legal fantasies getting crushed in real time. If you enjoyed the breakdown, make sure to hit that like button. And if you didn't, go ahead and smash the dislike, because at the end of the day, engagement is still engagement. Drop your thoughts in the comments, subscribe to the channel for more courtroom madness, and I'll catch you in the next one.